Thank you everyone for coming. We really appreciate it. Like Jason said, this talk has come out of a paper that Kyle and Tom have been working on about kind of the patent troll phenomenon, a little bit of a case study, and some ways of helping our clients see these problems coming ahead of them and mitigating that risk that's associated with the patent trolls. And if anyone has any questions, please feel free to ask. Again, we will be distributing the presentation by email to everyone who's RSVP'd. And also we will likely, if you would like to see the full paper that this is based on, we'd be happy to send you a draft copy of that as well. So to kind of encapsulate the troll risk, we wanted to play a video that's getting some notoriety on YouTube, and it really shows the problem, especially that startups face in not only the patent field generally, but specifically with patent trolls. So let's see. Hi, I'm Kate Andreas.
And I'm Sergey Zubov.
And together with our friend Dmitry Kornilov, we co-founded Ditto.com. It's an e-commerce site for prescription glasses and sunglasses where you can create your Ditto, our name for a video of your face from your webcam, so you can virtually try on the glasses to see how they actually fit on your unique face. We've grown our team to 12, and we poured our hearts and souls into creating Ditto.com, so we hope you check it out.
But recently, we were hit by 2 patent infringement lawsuits. One of them is coming from a classic patent troll, a non-practicing entity whose sole purpose of existence is to buy patents and sue companies with them.
The other is from one of our competitors, 1-800-CONTACTS, who you might have heard of. They have a division, Glasses.com, that directly competes with us. And they're owned by WellPoint, a $20 billion managed care company that runs many of the Blue Cross and Blue Shield organizations. The 1-800-CONTACTS co-founder, Jonathan Kuhn, came to our website and created his Ditto when we launched last year. In and of itself, that's completely fine. Except a month later, they went out and bought a patent from a defunct company that they are now using to sue us with.
We did not infringe on that patent. However, it could cost us millions to prove it in court. We should be spending our limited funds on hiring people and marketing our business, not on litigation. We're hoping you will help us out.
So if you donate $30 or more, we'll send you one of these awesome t-shirts that say, "I beat trolls." We're also asking you to support the SHIELD Act. It's a really important piece of legislation that's set out to help reform our patent system. We really thank you for your support.
Thank you. Thank you.
That's good.
All right, so these guys have presented a lot of issues for us. They are in some trouble. They've started a company, they've achieved some level of success, and at that point you start to see some new issues and certainly unexpected issues. So and that's kind of what we want to talk about. So first they talked about this idea of the classic troll, or often referred to as non-practicing entities. So for a little bit of terminology, again, this concept is that there is, the fanciful troll who's basically waiting for you to cross the bridge and comes out and demands you pay so you can cross the bridge. And what happens in the view of startups is that the patent trolls will often wait until you hit a specific revenue mark that it's now worthwhile to come after and to threaten patent lawsuits unless you agree to a licensing agreement. They're often also referred to as non-practicing entities, with the idea of it being less derogatory than patent troll. Non-practicing entities is not quite as accurate because it also lumps in a lot of licensing entities that may not necessarily have the same aggressive model, the same abusive model. So if you think about, for example, a tech transfer at a university, the university itself isn't going to launch a product, and there is certainly a good and established model for the university to license out its technology and patents. The same thing goes for small or independent inventors or companies who are more focused on creating technology. And that's really, those could also be non-practicing entities, and you certainly don't want to group them together with the patent troll concept. Another term we like to use is patent assertion entities, or PAE. And that kind of refers to really what they're all about. Their whole goal is to obtain patents and then to use the threat of litigation to force people into licensing agreements. So that is kind of the classic PAE. They also mention their competitor, 1-800-CONTACTS. So what we have here is certainly not a non-practicing entity. 1-800-CONTACTS, sells glasses. They're like they said, they're a giant, part of a giant $20 billion conglomerate, and they also are using the patent system, going out and obtaining a defunct patent, or a patent that's not being used by anyone at the time, and using it to try to shut down a startup competitor. And that is a very common model for a larger business to keep out competitors from the market. And it kind of also shows the ability, what can happen, even if it's not the classic troll, and also it gives the opportunity that Ditto could have in the reverse. So why is 1-800-CONTACTS able to basically try to rip off Ditto by buying a patent that was freely available, apparently? So we'll talk about that a little bit. We'll also discuss, they mentioned kind of where to allocate the resources, right? So one of the things they said is that they don't have the money to spend to fight a patent litigation, which is perfectly accurate, and they should be spending that money on employees and marketing and growing the company. And one of the things that we would like to discuss is especially in the startup model, that once you start achieving a certain level of success, you need to start planning and budgeting for intellectual property issues. That has to be part of the resource allocation, not only for the acquisition, but also for managing the risk that comes with intellectual property and that you will eventually face when you reach a certain level of success. And finally, they also discussed supporting the SHIELD Act. So now with the notoriety of the patent trolls, there is a lot of efforts in Congress to pass laws that would limit their action and their activity. And so we want to discuss some of that, what's going on, as well as some more proactive things that companies can take to avoid this risk. So again, back to the PAE problem. Startups are a favorite target of the PAE. They don't have the resources to go fight it back in court. They also often don't have different revenue streams, so you might only have one product. And if the PAE is targeting that product, you're stuck. You can't switch to a new product, you can't abandon that product. You're almost forced, again, in a no-win situation. And often, too, for startups, again, they don't have the experience with patent law that a much larger company with an in-house staff and patent staff can have. So again, it's a situation where you don't know what to do. So in that case, startups are usually willing to take a license rather than to go fight this patent in court, even if they believe that they don't have, the other side doesn't have a good case. And the other issue is that the PAE is often going to price the license agreement on a royalty rate that is right in the sweet spot of, it won't kill the company because it doesn't do the PAE any good if the company that licensed their patent doesn't make money. They make money off these royalties. And at the same time, they want to make it high enough that they are making money, but low enough that it's not worth going forward. So, where do the PAEs come from, and how did this phenomenon come about? So, there's traditionally multiple different ways of looking at patents as an asset of a company. So what's the value of patents? The traditional way was looking at it as what's called the defensive way of looking at it. And companies would get patents to protect their inventions, at the same time to keep competitors from copying. You also gives you the ability to disclose your invention so no one else can file a patent on it, or a patent application on it, and in a lot of ways to promote cross-licensing. So again, the idea was that you had these two big companies, each with their stack of patents. They're not going to go to court and fight it all out. They're going to cross-license their patents. Everyone kind of shares that technology, and crisis averted. Now, there's the other way of looking at it is the aggressive way, and that's that patents are really a profit center. Again, they're an asset of the corporation, and there are intellectual property capital is often referred to, and the patents can be licensed or gathered to be licensed or sold to other entities. And again, that might be traditionally, it might be out of a big company that technology field is not in their core strengths, and they really don't practice it, and they want to sell it and monetize it. Or they might be, again, that that's the value of the company, is that intellectual property. So in order to generate that profit center for IP, you also need to generate licensing revenue. And there are multiple companies who do this quite successfully. So for example, IBM generates a lot of licensing revenue, and that's their business. And at the same time, they can also spin off, like they spin off Lenovo to a Chinese company, and they sold the intellectual property with that, as well as licensing the patents that they still keep. So a little bit of kind of a historical timeline. What you see is this graph shows the number of patent applications filed at the USPTO from the United States and from all companies, and you can kind of see this massive growth over the past 20 years. We've highlighted a time where there was, the government took a specific interest in trying to consolidate patent law to try to improve the court system and forming a patent-specific court. And since that time, also coinciding with the growth of the knowledge economy of computers and of biotech, you see this massive increase in patent applications, which also shows just the giant increase in the value of patents and their worth to companies. So again, here is the actual the market value of the S&P 500 components. You see in 1975, intangible assets, intellectual property is only 17% of the market asset and the market value, and now it's grown to 80% of the company's market value. So, as we're moving towards a knowledge economy, the market value of most companies is in their intellectual property, in their human capital, and much less in the traditional land and trucks and merchandise and that is considered tangible. So we looked at a specific PAE to kind of get a more clear picture of how they function and how they're set up. And this company is Baltatzis LLC. They're a very, very active company. PAE filed a lot of lawsuits and kind of show how they come about. So the company overview. Baltatzis as a company, its global headquarters is in Texas in a convenience store. It's a little P.O. box. That's it. That's the company. It's there solely to be next to a court in Texas where a lot of people get sued. The way it started is there are only 4 patents from a single inventor that was sold through shell companies, possibly associated with intellectual ventures, and then created this company, Baltatzis LLC. So intellectual ventures is the granddaddy of all patents. It is the biggest and the kind of most well thought out, and really the leader of that field. And that intellectual ventures was founded in 2000 by 2 ex-Microsoft employees, and they, in that time frame, they bought tens of thousands of patents and licensed, created these giant licensing patent portfolios that they have. Basically, it's a who's who list of who their licensees are: Google, Apple, Microsoft. But at the same time, they've created a number of shell companies, and all of these PAEs work through shell companies, so you don't see who the actual real owner is, who the real person that you're fighting in a lawsuit is. And that also adds to the difficulty of dealing with, is that you really don't know what you're facing. So the whole Baltatzis company is built around 4 patents. And these patents generally claim, or what is considered the invention, is a way of communicating through electronic devices to a customer, getting some sort of feedback, which is then sent back to a central location for either for modifying the product or bringing product improvements or for service. So Baltatzis begins bringing lawsuits in 2009 and has basically gone through a number of different technology fields that we'll go through in the next slide. The other interesting thing about these patents is now that they're actually all expired. So if someone was to start doing what these patents say today, you couldn't be sued. But the way patent law works is that you can go back for 6 years of damages. So anything that happened from 6 years before that lawsuit, while the patent was still alive, you can be liable for patent infringement. So the other interesting thing is that Baltatzis, their licensing fee to license these patents is 0.575% of product revenue. So again, you see a situation where if someone sends you a threatening letter of, well, we're going to sue you, we're going to take you to court for patent litigation, which, like the video said, can run in excess of $1 million, or you can pay us a royalty rate of 0.575% of your revenue, the vast majority of startups are going to take that off. So, a little bit of how they've enforced these patents. The arrows showing, again, where each patent has been enforced. And you can see there's a vast majority or kind of a vast array of different technology fields and different products that they've gone after, some of which don't seem to have a lot of commonality. So between printers and interactive chat, there isn't that much commonality, but the common feature, again, is this concept of sending a survey or sending a request through the electronic device that's responded to by the user, which sends information back. And the way most of these patents are written are very ambiguous. They can cover a lot of different items. A lot of times they were filed really early in kind of when the computer technology and the internet was really taking off. So for example, these patents were all filed in 1992. So again, you have these very broad, ambiguous coverage of a lot of different products. And Baltatzis too has not only targeted startups, but also targeted very large and established companies, and following a little bit of this sequence. Okay. So now that we've kind of understand what's out there, what the patent troll is, how they're set up, what can companies like Ditto do to kind of mitigate that risk and be a little bit proactive of the dangers that are out there? So why are we going to try to be proactive? Well, it really, it's pretty much if you're going to be selling something on the internet, you are eventually going to have to see this patent troll issue, or you're going to see patent issue. And the way it often works is that it's going to be they're waiting for a startup to generate enough revenue to actually be successful, and then to come after that and try to get a piece of that revenue. So it's not going to. So if you're going to plan to be successful, you should plan on facing this risk and solving this problem. Okay. So there is a number of current legislations that are pending, one of which being the SHIELD Act of 2013, and that's what they refer to. So what does the SHIELD Act do? The idea is, again, to try to attack these PAEs and to limit what we consider to be their abusive practices. So there is basically what they want to do, one of the big ideas is to change the way that damages and the attorney's fees are apportioned in the U.S. So traditionally in the U.S., you go to court and both sides pay their own attorney's fees. But in Europe, it's the loser pays the attorney's fees for both sides. So what the SHIELD Act does now is set it up so if you are designated as a PAE under the terms of the law, you pay the attorney's fees if you lose. So PAE loser pays attorney's fees, but a non-PAE loser pays their own fees. Everyone pays their own fees under the old rule. So that's kind of created some question over whether or not this is even constitutional to pick winners and losers ahead of time. It's also the way that they've defined PAE, it might be easy for them to circumvent that. And at the same time, it really doesn't do very much to lessen the threat of litigation. It might make the PAE think twice about litigating it, but it really doesn't prevent that litigation from happening. And at the same time, it really doesn't help startups very much, because this says, okay, well, if you go all the way through court and you win, you were right, the PAE was wrong, they'll pay your fees. That assumes you have the fees to actually go to court and fight it out to the end. So the SHIELD Act really is more like the Google and Apple Protection Act than an actual startup protection act. Those companies do have the funds to take it all the way to the end and get their money back. A startup does not. So that is something to consider where even, Ditto is telling us, let's support the SHIELD Act. The way it's structured right now, it probably really helps the big companies more than anybody else. Not Ditto, right. Another proposal is called the End Anonymous Patents Act. So like we said, one of the real problems with the PAEs is that they set up all these shell companies to hide who really is the person who's asserting these patents. So the idea of this act is to really try to clarify that, to break this fog, and to force PAEs to actually show who the real party in interest is here, who's actually making money off this transaction, who's controlling this litigation. And they're kind of trying to force that by saying you can only collect damages from the date where you give all this information to the patent office. You kind of show this trail of ownership. So here we think there's a way of, multiple ways of getting away around the act as it's structured. So for example, you could, let's say intellectual ventures again, because they are the biggest and most active PAE company, they could set up an acquisitions shell that would buy the patent, and that shell would then give the revenue right, would keep most of the revenue, but give all the right to sue to their enforcement shell. So under the rules of the current law, the enforcement shell, again, would be considered the real party in interest. They have the right to sue, and they're gaining some monetary benefit. And while we still have this, the hiding of the original owners and the real kind of the puppet master here, if you will, in this scenario. Some of the other things, yes, please.
So what's by hiding themselves, what is the advantage to them?
That's a great question. Mostly I think it's for example, Intellectual Ventures for a while had said that, we're only a licensing company. We've never actually sued anyone. We're not bad guys. We're not taking people to court all the time. That was one of their mottos, that they've never sued anyone. Now that changed, I think in 2010 is when they brought their first lawsuit. But it allows you to kind of, again, present yourself that, well, you're not this hyper-aggressive, lawsuit-happy company. No, you really give nice licensing terms, and you're not a bad guy here. I think that's one of it. The other one is, to go and collect attorney's fees, or especially if it's considered a frivolous litigation, they can try to, again, cut off those attorney's fees. So let's say you create one of these shell companies that really has no revenue and no money, and all it does is go out and try to get licensing agreements. Say they do go to court and say it's frivolous, and the court says, well, now you have to pay the defendant's attorney's fees. Well, they could say, well, we don't have any money, so you know, good luck there. So I think that that's some of the ideas of why we have, again, this kind of these various walls and hiding who the original owner is.
Just one more point to bring up. If you don't know who's suing you or asking you for a licensing fee, there's no strategic way that you can plan to attack that. For example, Intellectual Ventures, that's a $5.5 billion company. They have that much cash on hand, or they did at one point. So are you going to attack that company, or if it's Sunshine LLC that's asking you for this licensing fee, it changes the strategic way that you approach your response to the letter or the litigation. So that's another reason why this obscure sort of shell company layering advantages the aggressive party. Intellectual Ventures has to date over 2,000 shell companies that people online have tracked back to Intellectual Ventures. But as a private entity, there's no way or reason that they have to disclose any of that information. That's just internet sleuthing that has found out these 2,000 companies. But they use it as a way to cloak themselves, so that you really don't know what you're up against, and you know, that does change the strategy when people send out these threatening letters and or file suits taking you to court.
So, and more recently, there's also, I think, two interesting developments. Now the Senate has also introduced their Patent Abuse Reduction Act, and it kind of blends some of the SHIELD Act and the End Anonymous patents. It seems to be trying to address the constitutionality issue of only the PAE pays when they lose, to make it more loser pays regardless of who they are. So there are a lot more kind of legislative fixes that are going on. Also, interestingly, in Vermont, they actually passed a state consumer protection law for companies working in Vermont against against PAEs, specifically end users. So a bunch of companies were getting sued for using and infringing a photocopier. So in that case, again, I think Vermont has passed a law which says that the company who's threatening them has to, again, show who they are, explain in detail why they think that these people are infringing a patent, and basically kind of a way to try to prevent this, what they consider to be an abusive attitude by these companies. So it's a very active field right now. People are very interested, and there's a lot of efforts to try to come up with some resolution to the issue. But of course, with any with any legislation, it takes a while to get through, and there's no guarantee that it will get through. So rather than wait and see if we can get a legislative fix, we think that there is some steps that people can take right now to protect themselves and to plan again for the future. So what we're discussing is kind of a two-pronged approach, more for active mitigation to kind of avoid this risk, avoid royalties, and avoid possible litigation expenses. So number one, again, is to identify the risk, to figure out what PAEs do pose a risk to your business, and what patents pose a risk to your business, and then to reduce the risk by avoiding the PAE patents, and if necessary, to attack them preemptively.
How do you identify those PAEs? Do you look for companies, like do you look for PAEs that have sued companies in a similar business to yours, and so then you know that that particular shell company is going after videos online, or this one is going after file sharing, or whatever the case may be? Is that, because it seems like the big problem with it, it's all these shell companies, and there's all this mystery behind what they own and who they are. So I'm just if you could just clarify how you
Sure.
identify those PAEs.
Yep. No, that's a great question. It's so we do that right now. So that's exactly what. So one of our clients came to us with the same issue, and what they have noticed is that they are on not the first wave of people getting sued, but they might be on the second or the third wave. So usually the PAE comes in with a kind of a tiered approach where they'll go in with kind of their strongest target, what they have the strongest case with, and that would be the first group of targets. And once they've either gotten some sort of licensing revenue out of these targets, or again, take them to court, they use that revenue to then go on to the second group. So what you can do is, one option, just like I said, is you monitor, you can see litigation in your technology industry, you can see who's getting sued first, especially if you're a smaller company in the field where you might not have hit those revenue targets that make you a target. But you can, again, you can see what else is going on in the field, you can see what other litigations are out there, and you can see who's getting sued first and kind of judge the likelihood if you're next on the list, maybe next year or 2 years or something like that. So so we have kind of two options here. Go ahead.
Yeah, I had a question about that. What about, say, a company that was maybe going through a clinical trial and ran out of money, or another startup that just again ran out of money, but they're still sitting on their patents of the IP they created. Would they be then? But then they decide they have enough money to at least keep paying the maintenance fees on the patents and keep them active. Would they then be considered a PAE as well?
I don't think so, because until they actually go out and kind of start, they would be more like an NP, right?
Okay.
So they are not practicing their patents, in that scenario, it would make sense for them to go out. Let's say they don't have the resources to actually put this clinical trial to finish it. They run out of money. The results came back bad. There's a lot of reasons why they can't do it. That seems to be a great scenario for them to go and license the patents to someone else who can pick up where they left off and finish that trial, for example, right? So, and that's kind of the traditional NPE model. That's really a good model, and it promotes innovation because all that investment that they made into those patents, into that intellectual property, can be transferred because they have patents. They can get money back for all the investment that they put into it, and at the same time, someone can pick this up and actually finish it and bring a product that will help all of us, right? So that is really that's kind of the worry here of, this attacking the PAEs, is kind of throwing out the baby with the bathwater, right? We don't want to be so hyper kind of sensitive or aggressive in we have this serious problem right now that we have to solve, where we're kind of losing some of we lose sight of all the benefits that being able to monetize and to license your intellectual property, especially if you just don't have the resources to make a product to make it happen.
I had a client who was put out of business by Microsoft, and so that was they had a product just like you said, and then Microsoft sued them, and I don't know if it was sued, and they were just trying to put them out of business, and so they tried to license theirs to someone, because they had been producing it, they needed to get some revenue somewhere. So I mean, in a sense, the big company was winning twice.
Yep.
If say the Shield Act came in, the big company was winning twice.
Absolutely, yeah, and that's what you see too, is some of this, a lot of the push for this is, we see kind of Ditto as all right, this is like the face of this problem, but the real people who are pushing this are Google and Apple, and they could pass laws that really kind of hurt a smaller company, right? So Ditto had the issue where 1-800-CONTACTS went and bought somebody else's patent and is now trying to put them out of business. And if you go to 1-800-CONTACTS' website, they are trying to launch their own video your face and put glasses on. They haven't done it. It said it's coming soon. So they are doing the exact same thing. They are trying to put a competitor out of business, a much smaller competitor. So we're saying is, well, why couldn't Ditto have bought this?
why couldn't Ditto bought the defunct, the patent that no one else was using, that someone else invested in, and use it to protect their own business, to protect themselves against 1-800 contacts, possibly to protect themselves against a patent troll. If that patent is older than what the patent troll is trying to sue them with, well, they could say, well, this is already existing. So, you know, they can be a lot more aggressive and knowledgeable if they have that information in front of them. So that's one of the things we're recommending is what is a common practice is clearance searching. So patents and applications, U.S. patents and applications are all published online at the PTO's website. So anyone can go and see the patents that are out there and the applications that are out there. Now, there's a lot of them out there, and you know, you can do a lot of sophisticated ways of looking through it and seeing, you know, what's going to match up to your product and your business, and what are the risks moving forward. But at the same time, you have the opportunities not only as, you know, again, the PAEs have the opportunities to buy these patents and to enforce them against other people, but so do the companies, so do startups, so do regular companies have the ability to go and buy patents and intellectual property that other people might not be using that are much more valuable to you. And especially if no one's using them, they might be a lot cheaper than actually going through patent litigation. So again, one of the ways that it's done is this idea of the clearance study, where you take the product that you're looking for, you go out and you look through all the patents and applications, and you search and you see what patents and applications could be a problem. If you do it early enough in time, you might have the ability to actually design around these patents and applications. You know what's out there, you know how to tweak your product or your service to avoid the patents and applications are out there. Again, you could possibly identify things to license ahead of time or to buy ahead. That's another option. So if Ditto, again, went to, rather than buying the patent that no one was using, they could have asked for a much lower license. And again, if the person who owns the patent isn't aggressive, it doesn't have that same level of sophistication, you might get a much lower royalty rate. So, one option again is you do a patent search, you find out those patents and applications that are really the problem. The other option is to look specifically for PAE patents, right? So either because they've been used to sue other people, or at the same time you can watch for trends and watch for the patents that seem to really fit the PAE model. Very ambiguous, seem to cover a lot of different things, you know, could be applied to a number of different industries, and may often not really apply to your industry specifically, but just, again, a lot of the background of the internet, often filed in the, you know, early to mid-90s, and a lot of times they're about to expire. So what you see is, you see often, you know, the patent might have a few years of life left. That's generally the time where they're now sold and then enforced against them. Back kind of to the industry monitoring. So PAEs tend to cluster litigation within technology sectors. So if we go back to the Lotus, their first big litigation was against printer companies, and then they went to mobile apps and the various other technologies. Go ahead.
So your clearance opinion, is that the same thing as that's called freedom to operate?
Right. So that's those terminologies are interchangeable for the most part. Clearance, freedom to operate, right to market, and again, the idea is that you do the search, you see what's out there, you say, well, look, these are the patents that we found that are the closest or the most risky. You might need to change a certain aspect of your product or service. That way you won't infringe these patents. And at the same time, you can also, again, you might find patents that are old and expired and say, well, look, you're practicing something that's already been done, so there's a less likelihood that you infringe somebody else's patent. And while, again, it doesn't necessarily protect you from litigation, it helps you to know what's out there and to plan ahead. So to really reduce the risk of a successful litigation against you.
So how much does that clearance opinion or freedom to operate opinion cost?
It really depends on the technology and the search. So it's very specific, I guess, but it's much cheaper than a royalty rate or a litigation.
Okay. Well, I asked because startups always have to budget.
Of course.
Right.
Yep.
So, and we've asked a few people before, and it depends on the firm you talk to.
Yep.
And always gotten a response between 5 to 10,000 generally.
Yeah.
Is that the right frame you would?
I think that's a good fair range there. That's probably pretty accurate. You know, I think that's something too. Is it has to be part of the resource allocation and the budgeting. Now, again, it might not be necessary at the very beginning of the startup process, but once you do find, especially if you see a product that you think is going to be the successful one, then, and again, you start to, you know, becoming more successful, increasing revenue, it's certainly something that should be put into the budget at some point. Is that we're going to, and I think that it should save you a lot of money in the long run by putting it up in the front end. So definitely consider your intellectual property not only to protect yourself, but also, you know, to file your own patent applications. Again, so that way you don't have the risk of someone else stealing your technology. Some other things for industry monitoring is you can monitor other. Again, you see what happens with your competitors. If they're getting sued, you might be getting sued eventually. And that's, we've seen that recently where we've had clients who called us and said, well, look, we haven't gotten a threatening letter, but a lot of our friends have, you know, how can you help us?
Andreas.
Yes.
Sorry, just to that point exactly, is that something, I mean, if it's a company you know or it's friends of yours that are getting threatening letters, you might know about it, but outside of actual litigation, how would you know if companies were out sending threatening letters, but they always got negotiated kind of behind closed doors kind of thing? So how do you search those?
That's very tough.
Yeah.
That's very hard to figure out. A lot of times you can, you know, it is just it's very difficult to know. So in this case, again, it was basically one of our clients said that, you know, we know that other people got threatening letters. Can you do it? You know, you occasionally see it maybe in the news. You know, Ditto's talking about getting a threatening letter here, or getting an actual lawsuit. So those are all very difficult to do, and a lot of times too, you know, companies don't want to that publicity that, hey, we've signed a royalty rate with a patent troll or license agreement, because it makes them a target for other PAEs. You know, once they say, okay, well, we know you take licenses, now everyone's going to come and try to get their license. So it's very difficult to find out, you know, really who's actually received that letter, who's taken a royalty, what that royalty is. You know, you can go to LoadSys's website and they'll list, here are all the companies who have taken licenses from us. You don't know those terms of the licenses. You don't know if they've given a much better license to Google than they have to somebody else. So it's very opaque, and I think that's why you see a lot of the legislation is trying to address some of these issues of, you know, the hidden nature of PAEs. So another thing to consider too is PAEs often are going to keep patent applications alive at the patent office. That way they can watch as the technology changes and write their patent applications to cover that technology. And that is something that they can do throughout, basically for 20 years, the life of the patent. So that is another, so when we do identify possible PAE patents or applications, we go to see if they do have these continuations or some application that's still alive at the patent office. That way too, again, they have the ability to change their claims as the technology changes to capture new products. The other benefit, the benefit of knowing about these is that you can take a lot more proactive action at the U.S. Patent Office. It's a lot easier to go after an application at the Patent Office than it is in court. And the more recent amendments to the patent law have added added some of those tools for people to be more proactive against what are considered to be bad or abusive patents. Yes, sir.
So on the previous slide where you said that they're going to write into new patents things that do cover you,
Yeah.
doesn't that, don't you have a demonstration of prior art then? at that point?
Right. So what happens is that that application, they'll go back to the original filing date. So the application is written in a way to be, again, very ambiguous. So anything that was filed, was put into the patent office in that original date is they can put into their, they can still use to try to define their invention. So what happens is that they will try to use that ambiguous language that's been in there for possibly for 15 years to define their invention in a way that covers what's a new product. So it can be, it's very, difficult to predict that, but that's why a lot of times you can kind of see a troll application or a PAE application ahead of time, just because it's so broad and so ambiguous that you can try to twist it to cover a lot of things that probably were never intended to begin with. But as long as they keep it alive and they have that original date, then they can say, well, it was in the patent office before you came up with this product, so we should be able to cover it.
Do you agree, though, that with those sorts of generalized applications that the claims inside of it are harder to actually achieve by the PAE? Mm-hmm. Would you give us a little confidence back there, that these sorts of generalized patent applications, they'll find prior art from the 30s or 40s and say, this is just a natural progression or the next logical step with new technology. Do you agree with that, or?
I think there is a lot of that sense, especially kind of in the business method ideas where, okay, it's a known transaction that's now done by a computer. And that is a lot of what you see, part of the new patent law has a section specifically for those types of patents. And you can see that a lot in courts, and even at the Supreme Court, where the concept of, well, you shouldn't just be able to take something that was already known, put it in a computer, and say this is new.
On the physical product side, I'm seeing that same kind of thing where something previously was a spring and a rod is now a linear motor or something like that.
Mm-hmm. Yeah, and there's been some other recent case law, or not recent anymore, but a case, KSR v. Teleflex, which was basically a very similar concept of the patent was on a brake, and they went from a mechanical sensor to like a electronic sensor. And in that exact scenario, the court found where it said, well, yeah, just going from these electronic sensors were already known, swapping out the mechanical to the electronic sensor just would be the next progression, and they found that patent to be invalid. So the difficulty, though, is that they had to go to court to do it. So now there is some more options for trying to do that at the patent office itself, rather than having to go to court to go through that whole expense. And one of those options is what's called a third-party pre-issuance submission. So what the patent office has said is, look, we can't, a lot of times we can't find the best references that show that this has already been done. So now you have the opportunity, when a patent application is published at the patent office, to submit your own references to the patent office for them to apply against that application. So again, but you have to know that this application is out there. You have to know that it's published. That kind of goes back to being able to do some clearance searching, not even necessarily to actually have an opinion, but to know what's out there, to know the landscape, and if you do see these types of applications being published, to be proactive and say, look, I've already seen that before, and I know where it's shown in a different document. I'm going to give that to the patent office. And the patent office then, it's an anonymous submission. It's free if it's 3 or less references. So there's I think it's going to be a very powerful tool moving forward to try to limit some of these overbroad patents that are in the patent office right now.
Of course, you can choose not to publish your patent application, and then nobody sees it until it's actually. But
yes.
then there's that post-grant.
That's absolutely right. So there is that, you also, yes, if you don't want to file an application outside the United States, you can choose to have it not published. And that's a whole, that might be more popular now that you can attack published applications. And they've created another system for trying to attack those patents while still at the patent office, and that's called the post-grant review. And we'll look at that as well. So just a little bit of an idea, there's a time limit on when you can file these documents with the patent office, and it's usually the longer of 6 months after the application is published, or the first time the patent examiner really looks at the application. Here is, in different technology fields, how long it usually takes the examiner to actually look at the application. So you can see in the biotech, it's 6 months. In communications and computers, it can take up to 16 months. So it's also something to consider too. If people are looking to submit prior art, if you're in the biotech, you have to do it very quickly. If you're in the networking and computer fields, you might have some more time to look for references. So I can tell you from our own experience, we have filed several of those for our clients, resulting in the patent office rejecting an application based on what we submitted to them. Another application was abandoned. So I think it's going to be a great way of assisting the patent office, again, in the scenario where the application is published. So what happens if the patent's already granted? There's a process called re-examination, where you request the USPTO to reconsider them granting that patent. It can be done anonymously. But again, you have to submit documentation that shows, well, they give the patent office something new to consider that they didn't consider when they originally granted the patent. Now, if you go back to Lotus, 2 of those patents that are listed are actually in re-examination right now. So someone else has found references, has submitted them to the patent office and said, look, you should have never given these guys a patent in the first place, and this is why. Now this is a lot more expensive than the third-party submission. So not only the fee to submit it to the patent office, but also to get someone to prepare it. It's something that you certainly want to make sure is very good and well put together, because you might not have a lot of shots to take at the patent once you submit.
But yet orders of magnitude less than litigation in terms of price.
Right. And what you often see too is a litigation strategy of someone is in litigation and they'll file a re-exam at the patent office at the same time. That creates a lot of problems for the patent holder in litigation, and you can try to get the better result of either the court or the patent office. So some of the new things that came out of the American Invents Act, along with third-party submissions, is what's called the USPTO trial. So the idea of having a trial about the validity of a patent at the patent office and not in the court, with the idea that it should be much faster and cheaper. One of them is inter-parties review, which allows the people who filed it a lot more say in the proceedings. And then the other one is going to be post-grant review, which only takes place for applications that were filed after March 15th, 2013. And it's only available for 9 months after the issuance of the patent. So again, by doing a clearance search, you can identify these references and attack them while they're still at the patent office, while they're still more vulnerable than actually going to court and having a presumption of validity that you have to overcome. And the one interesting thing about post-grant review, especially for the computer and the software related patents, is that all grounds are available to try to knock this patent out. So it's not just you have to cite a reference. You can say, again, this thing is way too broad. This covers a natural product or an algorithm. You can assert any grounds you want to try to invalidate the patent. The other big difference here is that these are not anonymous, and the real party of interest has to say who they are. There is also a special part of the statute for covered business methods, which are basically business methods for the financial system, the financial sector, and that allows the person who's been sued with one of these patents to go back to the patent office and to argue that it's not a technological invention, and to again say that this is something that is not patent eligible, and the patent office should basically revoke the patent. All right, so that's some of the things that are currently happening at the patent office. At the same time, you see industry is trying to make their own or pool their resources together. That way they can, again, kind of have strength in numbers, especially, now that's something that certainly can help the startup, is that by pooling resources together, not a single party has to take all the weight of litigation. So what you're also seeing too is a lot of kind of innovative ways of finding old documents. So you see a lot of crowdsourcing, searching. So to connect it back to the third-party submissions, I think most recently in 3D printers, they used a crowdsourcing technique to find prior documents, which then they submitted to the PTO using the third-party submission system. So there's a lot of kind of innovative other ways of dealing with this issue that's not necessarily legislatively driven or part of the pre-existing tools. There's also been kind of new entities. One of them is Unified Patents, which is Google, NetApp, and a bunch of startups. They are trying to do their own industry monitoring, that they would warn their own members of the group. And I think that might be something, Jason, that would kind of go to what your issue is now. If someone in this group, you know, if you created a group where you said, look, if anyone gets a letter, you have to share it with the rest of the group, you might have a much better early warning system than you know, everyone secretly taking a license or not. And they're also planning on using this entity as a separate entity to challenge patent validity. So again, you have, you do recreate this anonymity due to the number of people who are in this group, and the group can take patents to court and challenge them without facing the fear of a countersuit for patent infringement. And something that we were discussing that we think would be cool would be, you know, a local consortium of a New Orleans type group, the New Orleans Anti-PAE Consortium, of a way again for local companies to band together, to pool resources, and again, especially with the idea of industry monitoring and early warning system, to kind of help each other out. To, if you do, it might be more worth your while to, you know, to warn other people of the type of letters and the type of threats that you're getting, rather than just try to solve it on your own. Okay. Any other questions? Yes?
I don't understand why that's not just plain old extortion.
That's a great, yes, that's a
Shakedown.
I think taking it to the end is, yeah, you can look at it as almost like extortion. It's, you know, the patents are considered valid, right? And these people have, under the traditional system, they have a right to their intellectual property. And the way a patent works is that you can only go and, it doesn't give you the right to do it, it only gives you the right to stop other people. So they're using that power to basically extort a license.
Why don't they go after them for free?
Well, because it's, I guess you can look at it from that the patent is a property right that's given by the government, you know? So the government itself is saying, you know, we, by granting you a patent, we grant you the right to go to court and enforce it.
So that their purpose is nefarious.
That might be one way of doing it.
There is one, recently we encountered something, and somebody mentioned it's a submarine patent.
Yeah, sure.
Yeah.
And there was a, University of UC Berkeley, I think, no, not Berkeley, Stanford had some patents many years ago about sequencing, DNA sequencing.
Mm-hmm.
So put the fluorophore in there, and you can sequence the DNA. The patent expired many years ago. And now they got awarded this year, based on that old application, on the same technology.
Right.
And we are doing something which we think can, in fact, I read the patent is not directly, but it's so broad that So what kind of situation is there, submarine patent?
Yeah, that was, I mean, that was a really severe problem, and that's one of the reasons they changed the patent law back in 1995, is to make patents expire from the day that they were submitted at the patent office. So, but it still exists, you know, and those patents still exist, and it's another way of looking at it is probably the kind of the post-grant review, is that somebody more directly impacted, or again, people with pooled resources can take that patent back to the patent office to challenge its validity.
Because this patent impact every biotech research.
Right.
Yeah. Yeah. So reexamination may be an option for that. Evergreening is the term for the for continuing a patent that, you know, should have expired long ago. They'll file another application, so they keep it alive. What Andreas was saying, that PAEs often do is they keep an application alive in front of the USPTO, so they can modify their claims slightly, or, you know, at some point, you know, push to get it allowed, and then they can start enforcing that patent. So you're right. It's an issue. It's an issue that hasn't gone away, even though the laws were changed in '95 to address it. Hopefully, we're on the tail end of it.
Probably need to talk to you.
Yes.
So the example you had with Ditto and 100 contacts was, were they going for a future infringement, or did they identify a patent that someone owed that Ditto was already infringing?
Yes.
Okay, so you could claim 6 years infringement if you don't own the patent. You can just buy it out.
Yes.
Okay.
And allegedly.
Allegedly, right.
Yeah, I mean, this is one of those patents that's written in a way to be very broad. It was a defunct company that had that intellectual property as an asset. That's what 1-800-Contacts bought.
Mm-hmm.
So, you know, they had done the legwork. 1-800-Contacts had done the legwork to identify this patent with this company in mind. They said, what intellectual property exists with this company in mind? And they go out, they find it, and they bought it. It just happened to be a defunct company.
I guess, so ownership doesn't matter. If you're owed infringement, or you have the ability to prosecute based off of infringement, that shifts with ownership?
Right. Yeah. So traditionally, if you own the patent, then you have the right to go and sue somebody on that patent. Now, people can set up, you know, licensing agreements and kind of say, all right, well, you know, maybe it's a university, right? And they don't want to sue anybody, and they want to set up a lot, but they want to keep ownership of the patent. They can say, well, here's a license agreement, and together with you also have the right to go and enforce this patent. You know, we are giving you that right from us. So it's usually it is the owner, but a lot of times, again, it can be part of an agreement that, look, we never want to go sue anybody. You can go sue them if you want, and that's on you.
Kind of similar to what you were saying before with, you know, potentially they'll have to show who the ultimate parent company is of these shell corporations. You know, right now when you do a patent search, you know, it comes up and it tells you the inventors and tells you who it's assigned to, but that's the original assignee. So what about when these transfer hands multiple times? You know, do they have any plans to, like, it'd be really helpful if you search for your patent and it tells you who it's currently assigned to.
Right, and you can go and see. So at the patent office, they have the tab is search for patent ownership. So you can see the kind of the chain of title, even that's not shown on the patent itself. You can see, but all of those actually have to be those assignments have to be given to the patent office. So and you're not obligated to do it. So there's parts of the statute that try to encourage people to do it by saying, you know, it's kind of like title insurance.
You're not obligated to do that? That seems...
No, you're not obligated to report.
If the government issues it to you, shouldn't they want to know who owns it?
Yeah, that would make sense, but no.
Yeah.
No, you're not, there's no
It's
obligation.
definitely
to
a
do it.
loophole that
Right.
exists in the system, and, you know, intellectual ventures is, you know, we're
Right.
using them as the poster child, but they take full advantage of that. Through the use of their shell companies, or just not filing an assignment declaration.
And that's why you see too, sorry, that's why you see too is a lot of this legislation is, that has that parts of, look, you need to assign your patent, you need to put the assignments in the patent office, we need to know who the real owner is. And I think that that's one of the things that there's not a lot of debate over, and that's probably something that could pass easily and probably would help.
At least give transparency to the system.
Right. All right.
The question came up going back to the Lotus slide. If you have a client come in to your office with like an idea to create an app, say like an app that finds food trucks around town, just for a hypo, are you telling them right away, like, look, you're likely going to have to pay licensing fees for the technology that you're about to develop to make this app that you want to make for your phone? Or is that not what you tell them? Because when I was looking at the Lotus side, I was like, okay, that can probably apply to all future apps. I'm sure thinking about all the apps that have been created, you know, how much different can you make yours aside from your end result?
Yeah, you're absolutely right. I think, you know, for us, and it's, you know, we certainly, even people who are coming up with new technology and might be filing their own patent applications, it's something I think a lot of, it's often recommended to do some sort of clearance or right to market to know what the risks are out there. I think, especially with some of these Lotus patents and the really early 90s computer patents are so broad that, yeah, it's really easy to infringe those patents. And I think, you know, fortunately, a lot of them are expiring now. And, you know, moving forward, I don't think it's going to be, you know, as much of a problem as just these super broad patents. I think the PAEs are not going away. But the super broad, really early internet infrastructure, very basic interaction patents, hopefully are going to be in the next, you know, few years are going to start being expiring. But I think too, if you are going to look at a mobile app, at some point you have to plan that this is probably going to happen. You know, that someone's probably going to accuse you of patent infringement, just like, because there are so many basic things that have to go in a mobile app. So, you know, it might not be, it certainly shouldn't stop you at the very beginning, you know, but if you start, you know, once you start planning for that success, that, you know, this is going to be a good product that people are going to like, and this is going to be successful, as part of that kind of resource allocation of how many people are we going to hire, what are we going to spend on marketing, part of it, I think, should be what are we going to spend on intellectual property, not only for ourselves, but for addressing the risks that we're going to face once we get enough revenue to become a target.
And just the other point, these specific Lotus patents expired August 2012.
Right.
So they're suing companies that infringed these patents from August 2012 back to August 2006. Kind of coincided with the development of this guy right here. So you see why they're strategically coming to market, or not coming to market, but they're imposing their suits onto companies during this time, because they want to capture a lot of these mobile apps and surveys and things like that that the claims read on.
Yes?
Are most of the PAEs in the information internet technology space more so than in like biology, medical sciences, things like that, like we're doing here and everything?
Yeah, that's a great question. So there are the real, I mean, the biggest group is in the information technology areas, but there has been a lot more activity that's branching out now. So one of our clients is a nutraceutical company who has gotten a threatening letter based on, you know, patents about nutritional supplements. So I think it's again going to be much more, and that's why again you see a lot of this legislation is that it's only going to increase as people have found they can make money on it, you know. So it is only going to increase. I think the computer technology and the information technology lends itself
a little bit better just because you have a lot of broad, ambiguous patents out there that are a lot easier to threaten people with. But I certainly, it's not limited to that field, and it probably will only increase moving forward.
Just to follow on to that, you know, increasingly, biotech sector is realigning their philosophy from this defensive to aggressive, from a cost center to a profit center. The great stat was that we found while we were writing this paper was that Dow had $25 million worth of licensing fees. They increased that fourfold to $100 million in 3 years by more aggressively trying to outsource their patented technology. They were a big company, they were filing a lot of patent applications, they were generating a lot of issued patents, and they weren't leveraging those patents to generate revenue. 3 years later, they had quadrupled their revenue stream. We're talking about, you know, big time dollars, billions, and when you get into that type of money, people change their philosophy. They see patents as something that are revenue centers. So it's a philosophical change, and it's going to apply across all industries. So like Andreas said, the tech sector, in terms of internet, computer software, that sort of thing, lends itself to being the first sector that comes up with this issue, but it's going to apply to, and it has already started to trickle into all other sectors.
All right, well, thank you very much.